Called David Clendon.
Thank you, Mr Speaker. Mr Speaker, it's a sad day that it looks as though this bill will go through the House today, and in future we will look back and regret that, or those supporting it will. This bill is intended to make society safer. It will fail to do that. It will make our prisons more dangerous for police, for guards and for the inmates, and it will not achieve the goal of making our streets or our public safer, or indeed feel safer. Mr Speaker, it's been interesting that when the Greens have spoken to oppose this bill, there's often been some amusement from some of its proponents to dismiss our objections because, after all, we're communists and watermelons and various other things that it amuses people to call us. I sort of enjoyed the irony of the fact that the most robust, the most comprehensive and the most damning objection to this very poorly drafted and poorly conceived legislation I heard at a Maxim Institute event in Auckland recently. Two gentlemen, Professor Warren Brookbanks and Dr Richard Ekins of the Faculty of Law at Auckland University, both people with considerable experience, extraordinary mana, and who've done a remarkable job in a very objective assessment of this bill. These gentlemen, I'm sure, would have no objection to me calling them conservative in their views. That is their position. They need to do that. And from that very objective, academic and indeed informed judicial position, they come back and say that this, I quote, "Parliament should not enact this bill." I will quote from some of the summary reasons they give why this Parliament should not enact this bill. They say that the bill departs from the central principle of just sentencing, which is proportionate response to wrongdoing. They go on to say that this three strikes regime, especially on strike three, ignores the nature of the offences, which include conduct that ranges from the relatively minor to the very serious. They point out that this ignores all mitigating and aggravating factors. The application of the regime, they say, will often be unjust. There can be no clearer and more damning language from two respected and highly qualified and capable judicial commentators to say that this will often be unjust in its effect, this legislation. They suggest that the regime will often impose grossly disproportionate punishments on relatively minor offences. In terms of we're told that this bill would have some deterrent effect. In fact, there will be none. We know this. This is in throughout the discussion, the analysis from all sorts of parties. The deterrent effect has been, well, it simply isn't there. I quote again the Professor Brookbanks and Dr Ekins. The application of the regime is unlikely to deter would-be defenders in general, or the offenders with one or two strikes in particular. At the last reading of this bill, we heard much about the fact that parole is a privilege and not a right for prisoners. And indeed, these two gentlemen in their analysis concede that point. They say, however, there is no need to cancel eligibility for parole to establish that parole is a privilege and not an entitlement. We simply don't have to go there. The way this bill is structured, it suggests that we in this House, the majority in this House who will pass this bill, know better in every circumstance than a judge or a jury who will hear all the mitigating factors, the whole story, everything that is said and done about a particular case. In terms of the cancellation of eligibility, the two distinguished jurists go on to say that cancelling eligibility for parole for all second and most third strike offenders will not deter, but will undermine incentives for prisoners to reform or to refrain from further offending in prisons. In other words, prisoners, inmates will have nothing to lose. They will have no opportunity, no possibility of parole. Therefore, what weapons, what tools, by what mechanism can the prison officers have to manage their behaviour, to endeavour to improve their behaviour or to prevent their further offending? This will make our prisons more dangerous places. It will make the job of the police more dangerous because they will be pursuing people who know they have nothing to lose. This is not good law. It's not well thought out. The summary of the two, of Brookbanks and Ekins, goes on to say The regime will remove the incentive for offenders facing a Strike 3 conviction to plead guilty or to cooperate with the authorities, which will sharply increase trial costs and impose unnecessary trauma on victims. We heard in the last reading that the removal of parole meant that victims would no longer need to address parole boards and relive their no doubt traumatic and unfortunate experiences. However, this simply will misplace, if you like. It will relocate the trauma they will need to go through because prisoners, or rather accused, who might otherwise plead guilty will have absolutely no incentive to do so, and in fact will have every incentive to not plead guilty. The final summary point they make that I will refer to, they say the regime has a substantial fiscal cost which would better be spent on, among other things, victim support, intensive policing and improving parole supervision. And it must be acknowledged there are one or two provisions in the budget we've heard last week, which actually do improve the situation. There is some useful money being put, and I see the hand of the Māori Party in having won those wins in the budget. However, it is still a drop in a bucket. It is inadequate. It will not be sufficient to turn around enough lives, and this bill will actually create many, many more problems than it could possibly resolve. Whenever legislation that's proposed and goes through this House, there is opposition to it. And very often it is very easy to see the self-interest of the parties who are objecting to it. And that is the nature of the democratic process. When we're dealing with commerce bills, clearly sectors within the business community will come and protect their vested interest by trying to support or not a particular provision in a piece of legislation. I sort of reflect on some of the groups who are objecting very powerfully and publicly to the passing of this legislation. The Howard League, with over a century of history in supporting the human rights of the accused and of prisoners. Caritas, the Catholic Church's public service, social service arm. The Rethinking Crime and Punishment group, directed by Kim Workman, a gentleman with experience as a police officer, working in the prison service, as a consultant to the area, and now as a volunteer for the trust. The Prison Fellowship, essentially a collection of church interests. I look at those groups and I struggle to see any group, any of those who possibly could be driven by self-interest to oppose this very vicious legislation. In this instance, it is clear that their concerns or objection are coming from a commitment to basic humanity, to genuinely looking for ways of making our communities safer, to protecting the human rights of inmates and accused, and also to making their workplace safer for prison guards and officers. Thank you. We have said something, the reference to the Californian experience. The original proponents of this bill looked at California as a glowing example of how three strikes regimes can give positive outcomes. This is a different regime that is being proposed, but the principle is the same. Mandated sentencing, longer sentences, tougher sentences, fewer basic human rights for prisoners. And of course the analysis was that this bill would remove or reduce the human rights of prisoners. We had Reverend Ron Givens here giving us first-hand experience and images of the direct impact of locking people away for longer. The fiscal cost, the human cost, the suffering, the danger to police and guards. These are not things we need to invent because there is evidence there that the principle, these regimes are in fact. The images he showed us were from the Correction Service's own websites in California. They were not manufactured images. They showed inhumane conditions, people who were being brutalised and more likely to further offend. We saw in our own televisions this last Sunday an example of two young men, one of them who committed suicide in prison and one who looks as though he will be going to prison. That young man heading for prison has committed a very serious crime, there's no question. What that young man needs is treatment. That young man going to prison would be an unjust outcome, and it is that sort of injustice that this sort of legislation will not only facilitate, but it will positively encourage. And we will continue to oppose this very poorly thought out legislation. Kia ora.